A very warm welcome to all our viewers and a very good evening. I'm very sorry, it's a good afternoon, in fact. Uh, Today's Education on Air features a very highly respected attorney, Mr. Jeffrey Sansweet. He is a shareholder of the health care law firm of Calindus, Sansweet, Durden and Burke Limited. I hope I got that name right. Which is located in suburban Philadelphia. Jeffrey has been with the firm since 1985. He focuses his practice on representing physicians, dentists, and group practices in transactions including employment agreements, partnerships, incorporations, shareholder agreements, operating agreements, practice sales and mergers, and leases. Jeffrey also advises healthcare professionals in tax, retirement, and fringe benefit planning. Jeffrey earned his law degree at Villanova, where he was a member of the Law Review and Order of the Coif, and his undergraduate degree at the University of Pennsylvania. He also received his Master's of Law in taxing from Villanova. Jeff is admitted to both the Pennsylvania and New Jersey bar. He has authored many articles and is a member of the American Academy of Ophthalmic Executives. Mr. Jeffrey Sansweet, it is great to have you with us on EMD Education on Air. Please do tell us a little bit more about your firm and, of course, on what you would be educating us with today. And, of course, you will have to excuse me on the pronunciation of your firm, so you will have to start with that.
No problem. Thank you for the introduction. Yeah, the name of the firm is Calagridis, Sansweet, Dearden, and Burke. I know it's hard to pronounce. The firm exclusively represents physicians, dentists, and other healthcare providers. We do transactional work like employment agreements and buy-ins and buyouts and sales and mergers. And we also have a litigator, so if any of the doctors get into problems with breach of contract or restrictive covenant issues or licensure problems, or employee issues or harassment cases, we also deal with that. Today, and my contact information is listed there, so even after this program and any questions are asked and answered, if anybody has any questions, feel free to contact me at any time. Today, I'm going to discuss some typical issues that are addressed or arise or should be addressed in an employment agreement kind of geared toward an associate joining a practice. And it really applies to any physician agreement, but there's a few things that I get into specific to ophthalmology. So without further ado, I will start the slide presentation. This is just kind of a quick outline and a list of bullet points in terms of what I'm going to address. I will talk about the term of the contract and termination issues, which is always very important. I will talk about the duties, the schedule, and the location. I will mention outside employment or moonlighting. I will obviously deal with compensation, which is another significant issue. I will deal with permitted absences. I will deal with fringe benefits, expense reimbursement, malpractice insurance, also very important, restrictive covenants or covenants not to compete, and non-solicitation provisions are always a significant issue. I will briefly mention some buy-in provisions. Obviously, that would only apply to private practices. And briefly go over some boilerplate provisions, and then also give you some negotiating tips at the end of the presentation. Okay, so first, term and termination. Many times you will get a projected start date in the contract, like July 1 of 2015, for example, but it will be your start will be contingent upon being licensed in the state, obtaining staff privileges at the local hospital, and also getting credentialed with all significant third-party payers. And some contracts specifically state that if you don't satisfy everything by a certain date, that the practice can withdraw the offer and terminate you before you even start. So a couple things. You want to make sure you start with the credentialing early because it takes a lot of time, and typically the practice will help you with all of that. And the other thing you may want to keep in mind when negotiating the contract is you may want to put a contingency in there or an exception in there so that as long as you're doing everything you can diligently, that they can't just withdraw their offer, but that your employment start date may have to be postponed. Okay. Many contracts, or some contracts, have a fixed term. It might be a 1-year contract, a 2-year contract, a 5-year contract, whatever it is. But typically, even if it's a 2 or 3 or 5-year contract, typically you can be terminated earlier than that. So you want to pay attention to those provisions. And also, many times it's what's called an evergreen contract. In other words, it might just say your start date is July 1, 2015, and it just continues on and on from year to year until it's terminated by the terms of the contract. Okay, so here's a couple examples. The first example is basically says that either party can terminate the agreement at any time for no reason, without cause, on 90 days advance written notice. And this is very typical. Most contracts will not give you a guarantee even for a year or two. The only exceptions to that are typically maybe some hospital contracts, or if you're moving across the country and their practice is willing to guarantee you a year. But I would say 99% of the contracts I see, there's a without cause termination provision with a certain amount of notice by either party. Now the notice does vary. The shortest notice you'll typically see is something like 30 days. The longest you'll typically see is maybe 180 days. But 90 is pretty common. Excuse me, and there also may be a specific provision in the contract that says if you give 90 notice, or if the practice gives you 90 days notice, they can actually terminate you immediately as long as they pay you your salary for those 90 days. And you want to make sure, if that's in the agreement, that your health insurance and other benefits also continue for those 90 days that you don't need to work. In addition, if for some reason you're getting paid purely on productivity, obviously you won't be able to produce for those 90 days, so you need a provision in there that protects you from that. Then there's a for-cause termination provisions in there. And there's an example listed here on this slide that basically says the employer can terminate at any time on the breach of any obligation under the agreement. However, the employer needs to give 30 days notice and give the employee the opportunity to cure the breach. So if it's something that can be fixed or cured or undone, at least you have 30 days notice to do that. Many times also you'll want, as the employee, to include a provision similar to this provision that allows the employee to terminate upon a material breach of the employer at any time on after 30 days notice and an opportunity to cure. But often the cause will be immediate. In other words, you won't get advance notice and you won't have any opportunity to cure. And some examples in terms of getting more specific of for-cause termination provisions are listed here on this slide, including things like losing your license or DEA registration, losing your hospital staff privileges. That one you want to maybe insert an exception if it's for a temporary suspension for less than 30 days if you're late with your charts or something like that. So you want to take a look at that one. Loss of malpractice insurance coverage, loss of billing privileges. This one's a little bit vague. Unprofessional or unethical conduct, abuse of drugs or alcohol, absence due to disability, and there's usually a time period in there. It may be 60 days, it may be 90 days, it may be 60 days in any 120-day period, but there's usually a disability provision in there. Another one is the violation of any policies, rules, or regulations. And with that one, you want to maybe try to get a notice and cure before termination is effective. And then there's also something like unsatisfactory performance, which is also pretty vague. And so you want to try to eliminate some of the vague stuff. In addition, many times the contract will say, here's a list of 10 items where we can terminate you for cause immediately. But it may say something like, for this purpose, cause shall include but not be limited to. So it might be those 10 things, but it could be anything else. So from the employee standpoint, you want to try to limit it and to say something like cause shall mean the following 10 items. So it can't include things that are not listed. Okay, moving on to duties, schedule, and location. The most common is in contracts is it's everything's very general. It might just say, you're going to provide services on a full-time basis in the specialty of ophthalmology, at any practice locations. I mean, that's the way it's typically set forth. It typically doesn't specify, 40 hours a week or 50 hours a week or 60 hours a week, whatever it is. If any of those issues are issues, obviously raise them. If you're working part-time, then it's more common to be specific. It may say you're going to work, Tuesdays and Wednesdays. It may say you're working, every morning. It may say you're working 3 evenings. So you want to be specific, and you also want to have any night and weekend obligations specified. You want to have the call responsibility specified, whether it says equal to all the other physicians or equivalent or 1 in every 4, whatever it is. You want to try to get as specific as possible so you know what you're in for. In addition, if the practice has numerous locations or more than one location, and you've been hired to exclusively work at one location and you don't want to go to the other one for whatever reason, that needs to be in the contract as well. Okay, moonlighting. Most employment agreements say that, especially where you're full-time, say you're working exclusively for the employer and you can't work anywhere else unless we give approval. You may be able to do some speaking or writing or expert witness or some other medical legal work or consulting work separately. And sometimes that's allowed, sometimes it's not. Sometimes it's allowed, but the practice keeps the money. The best thing for you would be if all of that is allowed, but you get to keep the money. If certainly you're joining a practice and you know of a specific moonlighting opportunity that you want to take advantage of, you certainly want to raise that issue before you sign the contract to get specific approval and have it listed in there. Typically, the practice will say, if they give you approval to work somewhere else, that they can withdraw the approval at any time if they think it's interfering with your work, and you're also probably going to have to indemnify the practice from any liability that they incur due to your outside employment. Okay, the all-important compensation. Most agreements in the field of ophthalmology do have some sort of guaranteed base salary. You know, I know in dentistry and in dermatology, where people work part-time, it's very common to just get paid a percentage of your collections or charges and not get any sort of guarantee. But in most ophthalmology deals that I see, you do get a guaranteed base. The salary depends on a lot of factors, including any experience you have, the location, how well the practice does, you know, whether you're a retinal specialist or a general ophthalmologist. But most agreements do have a guaranteed base salary in there. Many of them just have the first year's salary. Others give you kind of a guaranteed raise of maybe 5 or 10% each year. But like I said, most of them just include the initial guaranteed salary. Sometimes it's negotiable, sometimes it's not. If you're joining a small practice that's hiring somebody for the first time and you bring a lot to the table, you know, you may be able to negotiate a higher salary. If it's a larger group and you know, there's many other people in line that want to work there and this is what they start people at, then you might not have much leverage. Most contracts that do provide for a base salary also include a bonus provision or some incentive compensation. Sometimes the bonus will just be very vague, and it may say that you may receive a bonus at the employer's sole discretion from year to year and not give any parameters. More common, however, is a specific formula based upon your collections from services that you perform. Typically, there's a threshold of 2.5 to 3 times your salary. So if your salary is $150,000, it's not uncommon to say, you know, we need to bring in 3 times that amount or $450,000 before you get any bonus, because we have to cover our overhead and we want to make a profit. The best you'll ever see is really 2 times salary, and it goes up to as high as 3 times your salary plus your benefits. The percentage that you're going to get above that threshold also varies significantly. It could be as low as 10% of any excess over the collections threshold, and it could go to as high as 40% of collections above the threshold, and anything in between. In addition, sometimes there's a tiered bonus. So it may say, okay, to the extent that if, let's say your salary is $150,000, it may say if your collections are between $300,000 and $400,000, you'll get 20% of that. Between $400,000 and $500,000, you get 30%, and anything above $500,000 in collections, you'll get 40%. So it's tiered, with the theory being the higher your collections, the less the incremental overhead is, so we're willing to share more with you. But that's the most common type of bonus formula. Another one, which is pretty rare, and is based upon the owner's net income. Meaning it might say, okay, let's say there's a sole practitioner and they're hiring you and you're their first employee, and the sole practitioner made $400,000 the year before he or she hired you. The contract may say, look, as long as I get, after I hire you, as long as I get back to make at least $400,000 your first year, I'll share with you any excess profits. You know, maybe I'll give you 20% of those profits, something like that. That's unusual, but I see it on occasion. The other thing that's changing too, with the new healthcare regulations and the like, there's some different methodologies that are getting more popular. Instead of basing some formulas, instead of basing the incentive completely on collections, RVUs, work RVUs are now being used, which is a specific thing that CMS publishes and assigns a value to each type of procedure or visit, irrespective of what you charge or collect. So sometimes the bonus is based upon your RVUs. There's also quality measures, patient satisfaction surveys and points, and citizenship metrics and meeting administrative requirements. All of those are becoming more popular, especially with hospital and institutional employers as opposed to private practice employers. Your compensation also has to not run afoul of the Medicare fraud and abuse and Stark and state referral laws. I can't go into that in detail here. That would be a 2-hour or 3-hour lecture. But it's one reason to use a healthcare lawyer when you're looking at your contract, because they'll be familiar with those issues. My last specific comment on the compensation is some practice will provide you with a signing bonus. It's more common with an institutional practice than a private practice, but it's definitely worth asking for. Actually, one other quick point that I just thought of under compensation. In the contract, you want to make a couple things clear. When the bonus is payable, because sometimes it won't say, so maybe it's 6 months after the year ends that they decide to pay your bonus. I usually like to put something in that the bonus will be payable within 30 or 45 days of the end of your employment year. In addition, I like to put a provision in that gives you the right to review the practice's records to verify the calculation of your incentive, because maybe they made a mistake and maybe you've kept track of things and you can figure something out that doesn't seem right. Okay, moving along to permitted absences. Vacation, typically for a starting physician, you'll get 2 to 3 weeks vacation. Eventually goes up to some more, but usually 2 to 3 weeks starting and maybe another week for CME. Most practices don't provide for, quote, sick pay or sick time, because most physicians, don't stay home from work because they're sick. But there typically is a limit on how much you're paid if you're out sick or disabled. There might be a limit for that. And what's becoming more common is the concept of paid time off. So the contract may just say you have a total of 3 or 4 weeks paid time off, whether it's vacation, illness, CME, whatever it is, but it's just a fully combined paid time off. In addition, most contracts will provide that if you leave before the end of the year and haven't used all your PTO or paid time off, they don't pay you for that typically, and it might be prorated for a portion of a year. The permitted absences are typically listed in the contract itself with a private practice setting, but in an institutional setting, many times it's just referred to as an exhibit or a policy that's in place for the employer, and in which case many times it can be changed for all similarly situated employees without your consent. I didn't mention maternity leave in this slide, but most contracts don't get into maternity leave. You can certainly ask about it if it might be an issue. If it's 50 employees or more, you're subject to the Family and Medical Leave Act, so you get 12 weeks of unpaid vacation for maternity. But if you're less than 50 employees and the state doesn't mandate it, there's nothing really mandated other than to treat it the same as any other, quote, disability. I have seen in contracts where it's listed that some practices just say you can take all your paid time off and then we'll give you an additional 4 to 6 weeks unpaid time off, for example. But it does vary, and it's worth asking about if it's a possibility. Okay, moving on to some of the benefits. In addition to the compensation and the paid time off, private practices are starting to cut back somewhat on the benefits because they're getting more and more costly, and everything's getting tougher in general in medical practices. With health insurance, many years ago, and when I first started practicing, almost every practice, private practice or institution, provided full payment of health insurance for the physician and the physician's dependents, the spouse and the kids. Very, very common. That's still the case in some contracts today, but more often than not, it's just individual coverage that's provided, not family coverage. And more often than not, the practice may not even pay the full premium. You might have to kick in 10, 20, or 50% of the premium. So that's certainly something you want to ask about. Hopefully, you'll be on the plan from day one, and if not, if there's a 30-day wait, you should try to get the practice to reimburse you for your COBRA coverage that you may have to pay for. Life insurance is not that common. Usually it's just maybe if there's a group term policy, you may get $50,000 of life insurance, so you certainly want to get some on your own. Disability insurance, there might be a group policy, but most likely your practice will not provide you with disability insurance, and it's very important to get your own disability policy. Two main reasons why most practices don't provide disability insurance. One is it's very expensive. The other is if the practice provides you and pays for your disability insurance, the practice gets the tax deduction for it, but God forbid you become disabled and start collecting the benefits from the insurance company, they're fully subject to federal income tax to you if it's done that way. However, if you buy your own disability policy, you pay for the policy, not the employer. You don't get a tax deduction for that, but if you become disabled, you receive the insurance benefits income tax free. So that's why many people buy their own disability policies. Most practices have retirement plans. These days, most of them are 401k profit sharing plans. Typically, there's a 1-year waiting period before you get into the plan, but it's certainly something you may want to ask about. It's not always in the contract, but the practice can give you what's called a summary plan description to give you more details on the retirement program. Okay, those are the typical benefits. Now, in terms of perks or expense reimbursements, most non-discretionary items like licenses, medical staff dues, and DEA registration, most of the time the practice will pay for that directly or reimburse you for that. Many practices, but not all, will also pay for some of your CME. Typically, there's a dollar limit on it. I've seen anywhere from $1,000 to say $3,500 a year on that. And I know to go to the AAO meeting, is usually pretty expensive. So hopefully it may cover that. Professional society dues and journals often are paid for. Sometimes they have to be pre-approved. Sometimes there's also a dollar limit there. Some practices will reimburse you for your board certification fees and may give you some extra time off to take your boards. Some will give you a moving expense reimbursement. Typically, it's around $5,000 limit. I've seen as high as 10 or as low as 2, but the typical moving expense reimbursement is 5. Many practices pay for your cell phone expenses, and pretty much all practices, unless you're working part-time and getting paid a straight percentage of your collections, pretty much all practices pay for your malpractice insurance. Okay, speaking of malpractice insurance, some states require a minimum amount of coverage, and in some states you're not even required to get malpractice. I know Florida doesn't require physicians to get malpractice insurance. I'm not sure about any other states, but I know it's true in Florida. And there's 2 basic types of malpractice insurance. One is called claims made, and one is called occurrence. Claims made is cheaper. available everywhere, and the most common. Occurrence is more expensive and not necessarily available everywhere. And the key issue, there's a key issue in the contract if you have claims made policy. Because, and let me briefly explain the difference between the two. With occurrence coverage, you are covered no matter when the claim is made. So if you work for a particular employer for 1 year and they cover you under their occurrence policy and you leave at the end of the year and go work somewhere else and your policy is canceled, and if somebody sues you 2 or 3 years later, you're still covered under that policy. However, with claims made insurance, in that same example, you're only covered for claims made during the policy year. So if there's a claim made a year after you leave, you have to purchase a reporting endorsement, or what's commonly known as tail coverage, to cover you for any claims that are made after you leave and the policy is canceled. So the key issue in contracts becomes, if it's claims made coverage, who pays for that tail? And the tail can be very expensive. The tail could be approximately 2 times a regular annual premium. So if your premium is $15,000 a year, and the premiums vary based upon subspecialty and state, but if your premium is $15,000 a year, your tail could be as much as $30,000 in a one-time lump sum payment. So certainly you want to try to have the contract read that the practice pays the tail no matter what. But I've seen just about everything in the contracts, and there is no real majority case, meaning I've seen many contracts where the employer is responsible to pay, many contracts where the physician is responsible to pay. I've seen contracts where the premium is split 50-50 or in some other proportion. And I've also seen contracts that say, if you quit, you pay the tail. If we fire you without cause, we'll pay the tail. And all sorts of variations of that. One thing that's particular to ophthalmology that may save you, there's a company called OMIC that's national, and that's for ophthalmology. So if you have an OMIC policy that's claims made, and you leave a practice and join another practice or go on your own and are able to maintain the OMIC policy, then nobody has to pay a tail and you're fine. But you don't necessarily know for sure that the next practice is going to have the same type of coverage. So that's one of the most contentious issues in employment agreements. And the next most contentious issue, other than maybe compensation, is the restrictive covenant or covenant not to compete. And a typical, sorry, I skipped the slide, so let me go back to that. Here's a simple example of a typical covenant not to compete. This says, during the term of the employment, during the term of this agreement and for a period of 2 years thereafter, an employee will not provide ophthalmology services in any manner or capacity within a 5-mile radius of any then existing offices or practice locations of employer. So let's talk about some of these items. 2 years is the most common. Sometimes it's 1 year or 3 years. The 5-mile radius of any then existing offices, I've seen anywhere from it being a number of blocks in Manhattan to as much as 100 miles in rural Texas and everything in between. I can tell you in the Philadelphia area, it's typically 5 miles. In suburban Philadelphia area, it's typically 10 or 15 miles. Almost every contract has a covenant not to compete. There's 2 types of restrictions in addition to the actual parameters of the covenant in terms of geography and location. One is injunctive relief, and one is liquidated damages. Injunctive relief means the contract will specifically say you cannot practice within that 5-mile radius, and if you do, we're going to get an injunction to shut you down, to close your office down, and actually prohibit you from practicing. The liquidated damages is a little bit different. It basically says that, hey, you know, if you want to practice within a 5-mile radius within 2 years, then you have to pay the practice a certain amount of dollars in order to basically buy yourself out of the covenant. Typically, it's around a year's salary. So if your salary is $150, you know, a typical liquidated damages provision will say, hey, as long as you write us a check for $150,000, you can compete with us. A little more detail on restrictive covenants, because they're very contentious and negotiated a lot. Sometimes they won't apply depending on the type of termination. So if either the employer terminates the physician without cause, or the doctor terminates for cause, it may not apply. In addition, certain states say that restrictive covenants for physicians are not enforceable. 2 of those states are Massachusetts and California. And in other states like Delaware, you can't actually restrict a doctor from practicing in an area, but you can enforce a liquidated damages provision in the contract. Okay. In general, when a judge or a jury or a court looks at whether or not it's going to be enforceable, because I get that question asked a lot, is a restrictive covenant going to be enforceable? And you never know. It's based on each case-by-case basis on the specific facts and circumstances, and generally just has to be, quote, reasonable. I mentioned before the different radius. It's not always set forth as within a 5 or 10 mile radius of any offices. Sometimes there's a map, and it may apply 1 mile in one direction and 20 miles in the other direction, depending upon where they get their patients from. In addition, it may not apply, or you may want, let's say the practice has 7 locations and you're only working at 2 of them. Often the restriction will only apply from the offices that you're regularly providing services at, or maybe spending at least 20% of your time. Okay, let me move on. We're running short on time. I have about 5 minutes more or so. In addition to restrictive covenants, there's often a non-solicitation provision that basically says that you won't solicit patients, you won't solicit employees, you won't solicit referral sources, and try to kind of steal the business away. Let me talk briefly about some buy-in provisions. Obviously, this only applies to private practices. Most practices don't put anything in the contract about becoming a partner, whether it's a year or 2 or 3 or 4 years down the road. Most contracts don't deal with it at all. To the extent that they put something in there, it's usually not legally binding. You may even get a separate letter of intent. It may be very vague. It may just say something like, you know, if we're happy with you and you're happy with us, and we're able to negotiate a reasonable deal, you know, we'll consider having you become a partner after a year or 2 or 3 or 4 years. It may go into more detail in terms of how the buy-in will be calculated, how you'll get to pay for it, how the net income of the practice will be divided, whether or not you'll be a full voting member, whether or not you'll get to buy into the surgery center or the real estate. And it's tough to know how much to push in terms of getting detail about this. Certainly, if you're joining a practice that has brought in partners year after year, and they pretty much know what the deal is going to be, they should be willing to share with you almost exactly what the deal is going to be. On the other hand, you know, if you're joining a sole practitioner who's never done it before, they'll be more gun-shy and less likely to know what the deal is going to be, and less likely to share lots of financial information with you. before you even start practicing. But it's definitely worth asking about partnership and getting as much information as you can, even if it's not in the contract. Okay, a couple boilerplate provisions. Sorry about that. You know, it's funny that I mentioned even though if it's not in the contract, because many times there's a clause like this that says this agreement constitutes the entire understanding between employer and employee, and all oral or written prior or contemporaneous understandings are expressly superseded, including a letter of intent. So that basically says, look, you get the contract, you sign it, no matter what we told you beforehand, an email or a letter of intent is irrelevant. Everything has to be in the contract. So, you know, to be enforceable, that's the case. Okay, I'm going to skip down. We're running short on time. I'm going to skip down to my final slide. A couple negotiating tips. One is be prepared. Kind of do your homework about the practice before you visit them, before you have your interview. Keep in mind, oral promises are not enforceable. It doesn't mean you can't believe them, but if it's not in the contract, you know, you can't sue for it. Typically, well, you can, but you're probably not going to win. Make sure you understand the agreement. You're not going to get everything you desire, so I like to focus on the key issues. You know, don't expect the practice to just do everything that you think would be reasonable. Try not to take things personally. It's a business thing. Try not to pay attention too much to what your other colleagues are getting or what other deals you have are, and my advice typically is pick out the practice that you like the most and feel comfortable with the most and just negotiate the best deal you can with them. Leverage is certainly key. If you know they desperately need you, you're going to be able to probably get more. If you know they've done things a certain way and there's others in line, if you say no, then you're likely to get less. And you know, the last thing, if possible, you know, you should have an attorney review your agreement, specifically a healthcare attorney, not your you know, sister or brother who may do personal injury or family law or criminal law, because it's helpful to know, you know, what's typical in an employment agreement. And I'll just return back to my initial slide for my contact information. And I appreciate you guys listening this afternoon. And now I believe it will be opened up to questions. Thank you.
Yes, thank you very much, Jeff. That was very educational indeed. Thank you. And to be very frank, I have got one question here.
Okay.
And he says he's a doctor, and he says according to duties, schedules, and locations, have the payment got to be different. Also, have the payments or salaries got to be shown in the contract, and cannot it be shown separately?
Let me answer the second part first because I'm not sure I understand the first one. But the second part, yeah, the compensation should be listed in the agreement. And if it's not listed specifically in the agreement, it can be in an attachment or addendum or an exhibit or a schedule, as long as that's referred to in the agreement and attached to it, you know, when it's signed. I'm not sure what the question is. Could you repeat the question on the duties and the location?
According to the duties, schedules, according to the duties and schedules, can the payment be deferred? Can the payment be different according to the duties and schedules?
Oh, I understand it. Yeah, sure. So in other words, I think this is the question. If the contract may say, you know, you'll get paid $40,000 for each full day worked or something, you know, on a weekly basis. So if you work 2 days a week, you make 80. If you work 4 days a week, you make 160. Yeah, sure. It can definitely vary based upon your schedule and your duties.
Yes. Okay. And yes, we do have another question.
Okay.
It says you mentioned that the contract should advise on bonuses. Should this really be mentioned on the contract?
Oh, the bonus formula should definitely be included in the contract. Otherwise, there's a good chance you're not going to get one. So all the details of that definitely should be included either in the contract or on a schedule or exhibit that's referenced in and attached to the contract.
Okay. If you would give me a few more minutes.
Sure.
Yes, the second question, he is saying that he's a doctor. I'm a doctor, and I want to know whether my employees or my employees who get the contracts, whether the bonus points should be included in the contracts.
Yes.
Okay.
As long as for physicians, yes. I mean, if you're doing an employment agreement for a receptionist or something, no, you don't need one. But if you're employing a physician, then yeah, if you're the employer and the employee doesn't ask for it or care, then you don't have to put it in there. But if typically it would be included, yes.
Yes, I think he's a doctor and he wants to know about
Right.
his receptionist. Okay. So that is basically what we have got today, the two questions.
Okay.
And of course, thank you very much, Mr. Jeffrey Sunsweet. Thank you very much for spending your time with us
My
and
pleasure.
for educating us today on contracts. And of course, to all our viewers, thank you again for being with us. And we will meet you again with another education on air with the EMD. And for the moment, it's goodbye from us. Have a good day. Bye-bye.
Bye bye.